Let's bring in criminal defense attorney and federal litigator Vikas Bajaj talking about the current trial underway. The former president was asked why he did not testify, and he said this.
Because he made rulings that makes it very difficult to testify. Anything I did in the past, they can bring everything up. The other reason is because they have no case. In other words, why testify when they have no case?
If you were defending the former president, Vic, would you put him on the stand?
Absolutely not. And it really isn't because of the former reason, the fact that a lot of impeachment evidence or attacks on his credibility would come in. It's for the latter reason. The people have not met their burden. Let's not forget, the burden of proof is solely on the prosecution. They must prove every element of this offense beyond a reasonable doubt, which is the highest standard of proof we have in the American judicial system. This case should fall on its face in front of any reasonable jury. There's absolutely no reason to risk your client testifying, former president or not.
But which brings us back to the thing where a lot of people, Jonathan Turley, we have a list of legal analysts, including legal analysts on some of the liberal networks, are saying, yeah, I'm not sure the president's getting a fair shake on this trial. What would you were weighing in on this? What would you say?
It is so hard to disagree with those opinions. Having handled many trials in my career, actually in a trial right now, as we were talking about briefly, the rulings this judge has put forward scream of bias, scream of motive to make sure President Trump is convicted. It's so hard to put into words how outlandish these rulings are. But when you handicap and handcuff a defendant or any witness to the point where they just simply cannot testify because all types of unfounded allegations will come on in, the proof is in the pudding. That puts the defense in a handcuffed situation, and the prosecution has the ability to ask what they want, question what they want, and present evidence as they wish. Don't forget, the judge did not allow a former chief prosecutor to testify who had direct impeachment evidence of Michael Cohen. So clearly a biased judge, in my opinion.
Even Trey Gowdy, who was a great lawyer back in the day, who never lost a case, said, he can't believe the strike zone for the prosecution and the strike zone for the defense seems to be a lot smaller. Meantime, in the hearing in Florida in the classified documents case, the judge, Aileen Cannon, was talking to the prosecution saying, listen, you said that these documents could be released without being redacted, right? Now they want the documents redacted. She says the following: the court is disappointed in these developments. The sealing and redaction rules should be applied consistently and fairly upon a sufficient factual and legal showing, and parties should not make requests that undermine any prior representations or positions except upon full disclosure to the court and appropriate briefing. I mean, you get to the minutia. The question is this thing ever going to go to trial, Vic, before the election?
No, it will not. And you and I have talked about this before, but it's very important to understand why this judge is so upset. Jack Smith, special counsel in this case, said, Judge, early on, I want the public to know everything. There are no secrets. But when the defense files documents under seal with the judge, the prosecution then says, well, hold on, Judge, that's a little inflammatory. That's prejudicial to the prosecution. It just doesn't sound right. Why don't you seal it? So the judge is caught in a quandary. In federal court, when things are filed, they're filed in person if they're sealed, or electronically if they're not. And if the judge doesn't know if there's an objection for each document, in a case like this with dozens of motions pending, it's both frustrating and it should not be allowed.
Yeah. Vikas Bajaj, great analysis. Thank you, sir.
Thank you.